Let's hone in on one of those headline stories now. The Public Protector, Advocate Busisiwe Mkhwebane's fight to stay in office continues. Mkhwebane says she's considering her options after being given 10 days to explain why she should not be suspended by the President. Earlier this week, Parliament announced that it will resume proceedings looking into her possible impeachment. For analysis on the way forward, let's bring in Advocate Modidima Mannya, who's the Chief Legal Expert with UNISA. Advocate Mannya, it's great to have you on the program. Thanks so much indeed for making time. On the face of it, what do you reckon is the game plan here from the President? Is this something that's merely procedural, or do you think he's rightfully being legally circumspect about what to do next?
Yes, good morning. And just a correction, I'm no longer at UNISA.
All right, got that. Thank you.
Yes. You know, I think the situation as it unfolds is getting more and more interesting. Just to give some bit of background, there's a multi-phase of processes here. The first process is that there should be a complaint, and that complaint was made. And the second phase was for the National Assembly to determine whether to investigate, and they started with a preliminary assessment of an independent panel, which then found that there was a prima facie case for the Public Protector to be investigated. Then Parliament took another step to take a formal decision to investigate her. And once that decision is made, it triggers Section 194 of the Constitution in terms of the President considering whether to suspend her or not. And I think it is in that context that the President issued her with a notice to show cause why she should not be suspended pending the conclusion of the investigation.
And Parliament has also, been at pains to explain that this is not a prosecutorial process that they're going to embark on. It's inquisitorial in nature. Help us understand in that world what would justify Mkhwebane being suspended when essentially this is, and you'll correct me if I'm wrong, but this is an information gathering step.
No, it is not actually an information gathering. The information gathering happened with the independent panel. At the moment, this is a formal process of a special committee of the National Assembly, which must then make a firm recommendation to the National Assembly whether the Public Protector should be removed from office or not. So there has to be a finding whether the Public Protector committed misconduct or is incompetent to warrant a removal from office or not. So it's not necessarily just an inquisition into whether it should happen or not. They have to make a definite recommendation to the National Assembly.
And why is it not able for that process to unfold while Mkhwebane goes on with her other work?
You know, the Constitution gives the President the discretion to make a determination. And I think the test would be whether it would be appropriate for her to continue to perform her duties whilst the investigation is being conducted. Now, as you know, there's been quite a number of things which have happened. One of them is that the Public Protector has been in and out of court in circumstances which may give credence to the fact that she is likely to continue misconducting herself. Because if you remember, some of the allegations against her arise from the adverse remarks or findings made by the courts. You'll recall that now recently she's filed a rescission application and she's made some very uncomplimentary statements to the Constitutional Court about how it probably failed to even apply the most basic of legal principles. Now, that's quite a serious statement to make in the circumstances. She has already insinuated or at least stated that the President is biased against her. She has said in her perjury matters that the charges against her are contrived. That all those things may give a sense that you are having somebody who does not necessarily even have the slightest appreciation that some conduct must change at the least. You will also recall that she has been in a sparring match with Parliament with regard to the rules. Even as the Apex Court made a final determination that the rules are no longer are not unconstitutional, with the corrections that were made by the Western Cape High Court, she still persists with that. So it may actually create a problem because the president has to weigh all those factors. But you must also remember that part of the investigation relates to the work that she has done. And there's the staff of the office who may have done that, who may have to testify. There might be an apprehension of victimization and those kind of things. So the suspension part is mainly to protect the process as opposed to being a determination of whether she's guilty or not.
The complexity doesn't end there, though, Advocate, because we're also dealing with a situation where the president himself is among those who've been investigated by the public protector. In that world, should the president be the one, given the perceived conflict of interest, to actually be handing out a suspension if he decides to do that?
Well, you must remember that the matter of the president and the public protector went to court, and the court found against the public protector. So you cannot hold it against the president that he exercises his rights. In fact, the very essence of the public protector's fight, she says, is to assert her own rights. So if she can go to court to say, I'm being done in an improper manner here, she must expect that everybody else can do that. But the matter of the president has been resolved by the court. There's no adverse finding against the president which can suggest any sense of bias against the public protector. So I don't think the president is conflicted. In fact, he is not making a finding about the guilt or otherwise. He is dealing with a procedural matter. If I may take you back to what the independent panel said, they said that the judgments and the adverse findings of the court should not be regarded as conclusive. She must still be afforded an opportunity to make representations and lead evidence on those adverse remarks. So the matter is not concluded. So the president is not involved in the determination of her guilt or otherwise.
What an interesting set of circumstances. Thanks very much indeed for helping us connect the dots. Advocate Modidima Mannya is a legal analyst. Appreciate your time.